So I'm going to start out the afternoon back to a little bit of the technical side of things. We're going to talk about a couple of real important topics for tribal courts. Of course, due process is kind of something that we always have every conference, every time, because it's a real important piece of doing our tribal court work. And we're going to also talk about appellate courts, because we rarely talk about those. There's an important reason why we want to start talking a little bit more about appellate courts, and you're going to understand why. So due process, and this is another one too for those of you that are new to the tribal court world or Indian law and that type of a thing. To just kind of bear with conversation. We're going to try to make it as user-friendly as possible with this idea of due process, such an interesting sounding thing. Must be legally very complex, and I guess you could make it that to be, because there's a lot of different ways to look at it and to talk about it. That basically it's the right of people involved in a court case to have their court proceed in a step that will be fair to everybody. Okay, so that's a pretty broad meaning. That, of course, means something different to California, maybe, than it does to Alaska, than it does to Chalkidzik, than it does to Navajo. These different governments have different ideas about this due process. But it basically means to have a process that's fair to the people involved in your courts. Now, I've been at this kind of teaching about federal Indian law and things like this for a long time. And I know at least 20 years ago I used to say, the United States Constitution doesn't apply to the activities of tribal governments. And people were like shocked. Okay, you're kidding me. It's the supreme law of the land. Okay, but it actually doesn't apply to the activities of tribal governments, the United States Bill of Rights. But in 1968, was a period of a lot of civil rights. Okay, it was an interesting time. I remember the time as a teenager, actually, because the Vietnam War was happening. There were a lot of protests, and there were a lot of kind of civil rights activities going on. The United States Civil Rights Act and things like this. And Indian tribes weren't left out of the business. And it was that time that Congress decided that they were going to also do a Civil Rights Act that applied to all tribes in the United States. So, the Indian Civil Rights Act. And it applies to all tribes, okay, in the United States. And it requires your tribes, basically, it's like the United States Bill of Rights, looks freedom of assembly. Sometimes I get calls from people going, the tribal council says we can't meet. And I said, you have the freedom to assemble. You can't talk. Your tribal members can get together if they want to assemble and talk. They have freedom of speech and freedom of assembly. It looks very similar to the United States Bill of Rights. And one of the things that it does in there is it basically requires your courts to give due process and to be fundamentally fair. Okay, so that's really where this kind of law is coming down in terms of requiring your courts to provide due process. Back in. So, in kind of the three main components, and you guys get sick of hearing us say this because we always say this, what are the three main elements of due process? And they're pretty simple. Notice. That means that people have to know if you're going to have a hearing about them. If you're talking about taking custody of their children or something like that, and you're going to have a hearing, they have to know about it, okay? They have to know about it. Notice, that's pretty fair, kind of a thing. It's kind of in the details, the devil's in the details about how you do that. And I think Kevin's going to be talking more in details about this. You have to have the opportunity to be heard, okay? In a state or federal court, oftentimes your opportunity to be heard is usually a couple lawyers arguing with each other, right? You're not even usually saying your side or whatever. That's the opportunity to be heard. And I think the beautiful thing in the tribal court, especially in the tribal courts, at least in Alaska usually, is everybody is having a wonderful opportunity to be heard. Things are being talked out to great length. So you have have the opportunity to be heard. You may not choose to take it and come to the hearing and be heard, but you have to give the person the opportunity to be heard. And then the one that's a little trickier is, well, you have to be fair, and as Andy explains it, that the judges shouldn't have their minds made up before they even hear anything about the case. And you have to have a fair and impartial tribunal, they call it, or judges. And that's a little bit more tricky because of the close relationships. You're all big families and you all know each other. So that one's the one that gets a little more difficult, the fair and impartial tribunal there. But those are, kind of that's the most fundamental kind of definitions of this due process. So it's taken Alaska Natives a long time. I started working for tribes in 1979. The state of Alaska said tribes did not survive the Alaska Native Claims Settlement Act. And it took a lot of activity on the part of tribes to organize courts and do things that created some court cases to challenge them, which created kind of now the laws that led to the formal federal recognition and led to the recognition of tribal jurisdiction, particularly over domestic relations, even without Indian country. So it's by litigation that tribes have kind of gotten this far, I think, in Alaska. And I think at this point in time, a lot of the litigation's now going to surround ideas of due process, okay? How they're supplying it, how they're not supplying it, this and that. And I think that Aaron's going to be able to shed some light on what I mean by that. So anyway, this John versus Baker is what we call a benchmark case in Alaska Indian law there, and it basically said that tribes have inherent powers. We've been talking about that for a day and a half, so we kind of beat that dead horse. But you know that tribes have their powers are inherent unless they've been specifically stopped by a federal court, right? Okay, we all got that. So they agreed in that John versus Baker. That was 1999. And that they can do this without having to have Indian country. But look at the bottom bullet there, okay? This is real important right now to the discussion here, because it says state courts should afford no comity. That means recognition or respect. Just one of the ways courts can look at each other's orders, that they shouldn't afford. They won't recognize tribal court orders in which a litigant, a person in front of the court, is denied due process. So, yes, you have jurisdiction to do child custody, but you have to, the state and states recognize that, but you have to give due process, okay? You have to give due process there. But the bottom one that's underlined is real important. But this due process analysis in no way requires tribes to use the procedures identical to ours in their courts. Big deal, okay? That's a big deal. One of the things that was argued in this Parks case was, well, tribes, if they're not letting two lawyers argue, oral argument, then they're not giving them due process. State Supreme Court said, no, we don't think that's true, okay? So you see what I'm saying? It's going to be arguments over the details of how tribes give due process, but you don't have to do it the same way that the state does, or the federal government. So that's real important to get back to Andy again. Okay, so he talked only about, he didn't only talk about due process, he also mentioned best practices. Okay, and so these are some of the best practices. Keep a record, okay? Real important to keep a record. And that's going to be important for our discussion about appellate courts, because the appellate courts look at the court record. Okay, so keep a record, keep good case files, and all that. Allow appeals. Tribal courts are not required to have appellate courts. You're not required to. But we've always recommended that tribal courts have them, at least on paper, because we've always waited for the day for this cart case when the state's going to say, wait a minute, You have to exhaust tribal remedies. You have to be able to go to the tribal appellate court, okay, before you can run to state court, with your problem there. So that was always a good thing a best practice there. Explain the decision. Natalie talked about that a little bit this morning, about explaining the decision. Why did you do that? We took the child out of the house because the parents were intoxicated, blah, blah, blah. To explain why you made the decision that you made, and to follow your own rules. Okay, and I'm a code drafter, and work a lot with that, and so kind of one of my soapboxes is that you really need to follow your own rules. You can make your rules, but you need to follow your own rules, okay? So if you say that your court needs a minimum of 3 judges to hear a case, then you really should be using 3 judges to hear your cases. Don't go outside of your own rules. If that doesn't work for you, change your rules, okay, and to fit what's going to work for you. So those were the kind of the best practices kind of outlined by Andy Harrington. These slides come out of a film. I think we ran out of copies of it. We have a basic tribal court film. We have more back at the office. I could probably bring some and have them available tomorrow, but that's where these slides are coming out of. Okay, so this is skipping on to what Aaron's going to be talking about just a little bit. In 2014, like I said, our Alaska Supreme Court said in this case that Aaron will be talking about is that parties have to exhaust tribal remedies. Okay, that's a legal term for parties have to be able to go to a second court if there is one, before they can run right to a state or federal court. So that's basically what exhaust tribal remedies means. So what is an appellate court? I was at a training not too long ago, and someone was going on and on about appellate courts, and there was a lot of people in the audience that said, I don't know what the heck that person's talking about. What is that? Okay, so I want to make sure we frame this discussion before we go into more detail. But basically, appellate court is like a second chance, kind of a watchdog, a second place where you can go. I think that they were unfair. I want to appeal it to another group of people to see what they think. So that's what an appellate court does. Its purpose is to review the court processes in a specific case and decide if the court was fair and if due process was provided. Well, if the court doesn't keep records, okay, of it, then it's hard to kind of review what happened down there at the tribal court level there. So that's why that good practice of keeping the records is real important. They're looking to see if notice was provided. Someone can say, hey, this decision, I wasn't even notified of the hearing. Hopefully, the court clerk has kept a return receipt little green card that says, oh yeah, you did get notice and blah, blah, blah. There. Opportunity to be heard. Okay, I wasn't allowed to even speak, at this or whatever. A fair hearing. Judges were biased. Okay, judges were not being fair. It's one of the reasons why we like to, when opening a hearing, make sure that the parties are comfortable with the judges that are seeing them. And it's nice to get that on record too, if they agree. Okay, it's always nice to have that. And that the court acted according to applicable tribal and federal laws, and that the law was equally applied. So you didn't fine Joe $2,000 for doing something that Fred did, and he only got $20 fine. In other words, to apply your laws equally. So the appellate court's being asked these, kind of looking at these things. Is that to see if that was provided. So they generally do not rehear cases. Okay, Thor might give us some more light on this, but that's generally not what an appellate court does. They look at the due process. They look for errors in procedures, errors in fact, due process, and things like that. The judge made a mistake in the application of tribal law, some kind of misconduct, a conflict of interest. A judge would not step down when it was his daughter coming in front of him. that, which is okay if it's an emergency, not okay if it's not an emergency. Okay, there. Or it was unreasonable decision based on the facts. So, then we come to this. Okay, so how do you make an appellate court? Okay, a lot of times villages are small. It's hard enough to make a regular court. Now we got to make an appellate court. Okay, another separate group of people to be the appellate court. And so I know in our region, I think in some other places, Kenaitze might do it this way. If you have your court separated from your council, then the council's your appellate court, basically. So that's kind of a typical pattern, that the actual tribal council is the appellate court if your bodies are separated out. That may or may not be the case, because I know in our region, a lot of the courts are made of pools of judges, and a lot of times, a lot of those judges are council members. Usually it's council members plus a pool of other people to make this pool of 7 to 10 judges that they can pick from. Okay, is generally what it is. So you've got to be able to write your structure so that it's different. If you use like 3 judges from that pool that you pick from your appellate court, it's going to be judges that didn't hear that case, that don't have a conflict of interest. An intertribal court is discussed a lot in Alaska. It's probably easier to set up than done because we talk about it an awful lot, but we don't have a lot of actual intertribal courts except for on individual cases I'll talk about in a minute, kind of set up. But that would be a good idea, I think, if tribes got together and had an appellate court, that kind of intertribal court to serve as that there. So have to be creative in terms of structures. Just a little bit about procedures. I think I mentioned already what I wanted to, but you want to, procedures are doing kind of basically what we usually use judicial codes. I know Thor's going to talk about court rules maybe with the way that they operate, but a lot of tribes up here use codes and where they put kind of procedures in there. It's typical for the code to say that a party has 30 days to appeal a case to this tribal appellate court. They have 30 days. And we kind of clarify that rule because sometimes it takes a while for the courts to issue their orders, to get them to the person. So most of our codes read that it's 30 days after the person receives the order, okay? Because sometimes it takes a while for the court to generate that order, okay? So that's generally what they say. So after the 30 days, they've exhausted their tribal remedies if they haven't appealed, okay? So that's kind of one of the things there. The clerk usually, so if someone files an appeal, okay, so court clerk, she gets this thing, and they filed an appeal within 30 days, generally what she'll do then is to notify appellate court judges, for a time to get together to take a look at this appeal. And the judges then will look at this appeal and look at the tribal court record and decide whether or not they think that they should, have a hearing to look at this to see what they're going to do. So if they decide they want to do that, the hearing date's set, and everyone discusses it kind of very similarly to the regular tribal court hearing, and then the judges make their decision. What action can they take? Okay, you like to have it kind of written out in your court rules or your codes, and so they can probably do a number of things. So, for example, they can just uphold the procedures and decisions of the tribal court and say, sorry, we think that things were okay and we're not going to make any decision here. What they might do, though, is they might send it back to the tribal court and say, hey, you need to hear this with different judges, or you might need to do something different, or you were unfair in this way and you need to correct that. So they might send it back to them. Then the third one, I don't know if they ever do that. Do they ever do this? Dismiss the case in the most serious circumstances. So that would be one too. Maybe you could mention something about that. Okay, what would cause them to do that? All right, so now, here's the deal. We've had, I don't know how many thousands of cases we've had in the last 20 years. Let's say 3,000, I don't know, 5, I don't know. We've had a lot of cases in our tribal courts in Tanana Chiefs region in the last 20 years. How many appeals do you think we've had? Yeah, we've probably had, I don't know if we've had 5. Okay, I don't think we've had even 5, okay, here. We've made, well, maybe let's say 5, out of quite a few thousand cases, all right? Interesting, you know. One of the reasons I think that happens is because we use panels of judges, okay? 3 to 5 judges are sitting there. That's usually what an appellate court has, right? And I think that the tribal court opinion is respected when you have a lot of people sitting as your judges. I think another reason is that our courts take a long time to talk things out and to try to get the right decision, to come to the right decision so it gets accepted. I think there's a variety of reasons why we don't have many cases appealed. Okay, so the challenge is then, all right, we don't have many cases. We're going to have this appellate court over here. We're going to get them all trained up to be appellate court, and then they don't have a case for 5 years. Okay. So that's just it. So every time we have had an appellate case, they call Tanana Chiefs, what do we do? Okay, well, fortunately we have appellate structures and procedures in their codes, so we kind of go back to that and try to help them with it. So that's one of the problems we have is the infrequency of use. Another one that we have is because the villages are small, because you're interrelated, because you don't tend to marry necessarily someone from your village, it might be the next one, we often have cases where 2 tribes might get together and form a joint court over a case. That's all well and good. Gives Michelle Gady heartburn because then she has to help to referee sometimes between those tribes. But you know, tribes can do that. They can join together. They can let this tribe be an intervener, just like an ICWA case. There's a lot of different things that they can do. But when they do join together, okay, now they're one court, they must decide ahead of time whose rules are we going to follow. Okay, they must decide that ahead of time. And they must decide, what if someone wants to appeal this? What are we going to use for that? Okay, so you must decide those things ahead of time. And we're trying to get tribes to do this in writing before they do a joint court together. So just a couple of little things to think about when we're talking about appellate courts there. Just back to that due process, because like Andy, I can't really go without saying it a million different times. So the basic due process, notice of hearings, opportunity to be heard, fair and impartial judges, and fundamentally fair, treating people equally. And then the best practices, follow your own rules, explain your decisions, keeping record of court proceedings, and have an appellate process. Even if you only use it once every 5 years. You need to have that so that people have an opportunity to exhaust tribal remedies. Okay, there. So basically, Alaska tribal courts have been fighting for respect from state and federal courts, as well as from their own tribal members. It's a long-standing process and battle there. So the path to really doing that is to be as fair as you can be. And being fair, you let people know about the hearings, you give them a good opportunity to be heard, and you're fair to them, and that you provide a second chance, okay? And you provide a second chance there to appeal it to. So that's just kind of a little bit of an overview for the panel about the due process and about appellate courts. And I'm really excited to have Thor join us. He's going to speak later, though. Sorry, Thor. He's an appellate court judge, so you know we just don't have too many people in Alaska that can say, "Yeah, I'm an appellate court judge, and I've got a lot of experience." You know, so we're real appreciative of that. Kevin's going to talk more about due process and things like that, and Aaron's going to talk about the relevance of that Parks case and that sort of thing. So.